Welcome to the e-commerce IP report.
Hello, everyone, and welcome back to the e-commerce IP report with Adam Urbanczyk. Adam's the principal attorney at AULLC, a Chicago-based law firm focused on intellectual property litigation, e-commerce disputes, and helping businesses protect their brands in a rapidly evolving marketplace. I'm Sean O'Connor, and today Adam and I are discussing what happens when your funds get frozen in an e-commerce IP lawsuit. Adam, good to see you.
Good morning, Sean.
So I'm a seller and I wake up in the morning and my funds are frozen. Why? Why do funds sometimes get frozen during an e-commerce intellectual property lawsuit?
As a seller, your funds can be frozen for, I guess, two reasons. One of which the predominant way in which those funds are going to be frozen will be as a result of the lawsuit, and particularly a temporary restraining order or a preliminary injunction that was entered in the lawsuit that has some asset restraint component. There is the occasion where the platform itself, based on what it perceives to be your platform policy violations, will just decide to restrain your funds.
Okay.
Which is a very common occurrence. It might be outside the scope of the e-commerce litigation discussion, and that's something maybe we can talk about separately.
Mm-hmm.
But I guess in the litigation context, the reason why the funds are frozen is going to be because a plaintiff in a lawsuit requested relief under a federal lawsuit under Rule 65 that will allow the court to enter an asset restraint under perhaps most circumstances across IP infringement claims. If it's a trademark infringement claim, there will be a remedy under 1117A. For the copyright infringement claim, 504A. If it's a design patent infringement claim, there'll be a remedy that includes like an accounting of the defendant's profits from the accused activity. And that accounting, that equitable remedy will, generally allow a court to restrain funds on a pre-judgment basis. Pre-judgment being, before the judgment at the end of the lawsuit, so
right
during the litigation.
Yeah. But the frozen funds aren't step one in this process, obviously.
No, the funds are frozen because, I guess the accused activity occurred and the plaintiff got wind of it and they collected some evidence, hired an attorney to file a lawsuit that included a complaint, a motion for entry of a temporary restraining order, perhaps a motion to seal. Maybe there was a motion for leave to conduct electronic service of process, but it's going to be, there'll be some steps in advance.
Yeah.
So how quickly can that happen? Depending on how perhaps how popular or how hot or enforced the products in question are.
Yeah.
You post the listing on Monday. Most large brands are going to have investigators or at least AI powered tools that are scanning all listings at all spaces, all times, all frequencies, all channels to see who's doing what. And maybe they pick it up. If you create the ASIN on Monday, maybe they pick it up on Wednesday. And they'll take a snapshot of it. They'll go through some buying process that pretend that they're ordering the product.
Right. Yeah. The secret shopper.
Yep. Maybe they will increasingly they'll be, consummating that purchase for jurisdictional reasons that we can talk about later. Or maybe they don't, and they just want to demonstrate to the court that, hey, this defendant was willing to sell me this counterfeit product, so the court should do something about it.
Got it. Okay.
And that can happen, so it can happen in a few days, particularly now because, the prevalence of GPTs and AI tools that are scanning everything.
They pick it up quick.
Turnaround time, pretty quick.
Yeah. What assets or accounts can sellers actually lose access to once the freeze happens?
Initially, it can be all of it.
Okay.
So, what the plaintiff is going to do is say in their motion for their motion for entry of a temporary restraining order, they're going to say generally, uh, I'm the plaintiff. This is my business. This is our business. These are our rights. This is what the defendants did. This is unlawful. Based on the evidence we're submitting to the court in the form of usually a declaration and some exhibits there too. There's a likelihood of success on the merits of our claims. We're probably going to win. Here you go. Here's the evidence at the outset of the case. This is prior to getting anything from the defendants in discovery. This is just the stuff we have.
Yeah.
It looks like we're gonna win. So given the nature of the rights at stake, so intellectual property rights and tangible rights, infringement of those rights is going to be, kind of irreparable, sort of implicitly. So there's not going to be an adequate remedy at law, and there's, the balance of harms of stopping the defendants from continuing to sell counterfeit goods isn't going to be outweighed by the defendant's interest in wanting to keep selling its goods.
Right.
So the court's going to say, okay, presuming the registration, like the plaintiff's rights look like they're put together more or less, and the evidence is pretty clear of what the defendants are doing, the court's going to grant that.
Got it.
Part of the order that results from that process is going to be, there will be some injunctive components that the platforms are going to be, prevented from continuing to infringe the plaintiff's rights. The platform has to take down the listings.
Oh, yeah.
If there are any advertisements, the advertisements that include the counterfeit products and the terms need to be taken down. Okay. And then there'll be a request for a prejudgment asset restraint. Most of the time, the plaintiffs, because the plaintiffs aren't going to know what the defendant's sales volumes are. So they're going to say, well, we don't know this, so freeze all of it.
Oh, yeah.
Now,
Assume the worst.
in a way, yeah, and it's defensible. If you're the rights holder, you don't know what, you don't know exactly who the defendant is exactly, or who their affiliates are, or who the suppliers are, or any of that. All you're seeing is an artifact of this, the accused activity, the listing, right?
Yeah.
That's an artifact of an operation that can be involved in a lot of things. So you're going to ask the court to freeze up to everything. That tends to shift the burden to the defendants then to show up and say, listen, yep, we were selling this product, and we can dispute whether there is, whether there was any infringement or however the plaintiff is characterizing that activity. But regardless, we sold 2 of these things for $13.
Yeah.
We sell 5,000 other products,
Right.
and you're freezing millions. And so you very often run into those situations.
Okay.
Um,
Well, let me ask you this about that. I'm a seller, and all of my funds, everything's frozen. What legal options do I have if I want to challenge the freeze and recover access to my funds? What do you tell sellers?
well, one, you should probably talk to counsel. It's a lot of time we spend involves motion practice over these issues, like the appropriate scope of asset restraints. You can't use the asset restraint, with the prejudgment asset restraint capability of relief under Rule 65 to just freeze everything. Whatever the scope of the restraint has to accord with the scope of the accused activity. And at least at the outset of the case, if the defendant is involved just because they're accused of selling this one product that had a problem, the plaintiff isn't going to, ultimately, when pushed, that is, if the defendant's attorney shows up and moves to modify it, isn't going to be able to, without more evidence from the plaintiff,
keep everything locked up.
Could exist. But if we're just talking about one product, that's the only evidence that supports any asset restraint. Well, the asset restraint has to be limited to just what that evidence supports. Because, again, the plaintiff is going to bear the evidentiary burden to establish whatever relief it wants under Rule 65 anyway. So ultimately, it's the plaintiff's problem to get the court to freeze anything. And then when you're talking about what the scope is, the defendant can show up and push back on that a little bit. So most of the time, most sellers aren't just selling one product.
Right.
No, it's always going to be an issue. Now, is the one product 85% of their sales volume, despite having, a portfolio that has dozens and dozens of products? Maybe,
Could be, yeah.
maybe. But if you're a seller and you run into this, what you would want to do is go through if you're on Amazon, for example, go to your Seller Central account, dump out the sales records of just the particular ASIN that was shut down. You will need that. Your attorneys would need that either in a negotiation. Maybe it's just a matter of retaining counsel and a reasonable conversation is had with plaintiff's attorneys saying, look, listen, here are the sales. We can dispute the infringing character, but for the moment, can you at least agree to reduce the asset restraint? Maybe they will be amenable to it. Maybe they won't. A problem with, on the plaintiff side being steadfast and demanding that everything be frozen is, well, one, if the plaintiff doesn't have any additional evidence of the wrongdoing aside from what it did in the pre-suit investigation, they're not going to be successfable in maintaining that asset.
It's not going to hold up in court, right?
Right. And if we're talking about lots of money, at some point the inability to access that liquidity will affect the defendant's business, and if that turns into that could be a separate issue for the plaintiff, or if it's determined that the rights the rights are bogus, maybe the registration is the trademark registration is bogus, or the rights can be affected somehow, or the design patent's invalid or something.
It could be a countersuit situation. The plaintiff could be opening themselves up to exposure there.
Yeah. So the defendant can always bring a counterclaim, and then for the injunction, the injunction itself, in order, the injunction needs to be supported by some security. So in most courts, the plaintiff will be required to post a bond of some amount, which exists for the purpose of basically compensating a defendant who was wrongfully enjoined.
Oh, okay.
So if I've had $500,000 tied up because you didn't agree to just reasonably, the plaintiff didn't agree to reduce the scope of the asset restraint to some other level or at all, and we had to engage in this motion practice. We suffered damages because we didn't have access to these funds and our business suffered. We weren't able to buy inventory, blah, blah, blah. Or, after the fact, the plaintiff's rights are invalidated, or it turns out for other reasons, the court found the injunction to be wrongful, then the defendant can go and ask the court for compensation from that bond.
I see. Makes sense. What about, you've been doing this a long time. Can you share an example of a situation where, a business was dealing with frozen funds and what steps they took to improve their position?
I think the defendants are almost always dealing with frozen funds.
Yeah.
The asset restraint component is going to be a part of most every temporary restraining order.
Yeah, it's a standard tool, so to speak.
So it's very standard.
Yeah.
If we can be retained, and the client will let us know, here's the sales records of the item in question. We can get a declaration from the client basically describing the business, including as an exhibit the sales records showing that these are the sales. We would reach out to plaintiff's counsel first to see if they're just willing, if they're amenable. Once we have the sales records from our side, if that comports with the information the plaintiff got from the platform, because the plaintiff's going to want to know what the sales of the accused products are. They're going to get that from Amazon. The defendant can get it itself from its Seller Central account. So we can say, here, this is everything. We're not hiding anything. We're on the same page. We can engage in this mode. We can move and spend that time, or we can just kind of come to some an agreed asset restraint. Sometimes the matter is resolved that way. The plaintiff is willing to, reduce the scope of that. So an agreed order can be entered, or if the plaintiff wants to fight it, you're left moving, asking the court via motion to modify the scope of the asset restraint for those reasons, basically that the scope is overbroad because it includes funds which aren't the result of the accused activity. And we know that because here's the accused activity. There's $1,500 worth of accused activity. and the asset restraint is restraining $150,000. Plaintiff doesn't have any evidence that the other funds are actually attributed to the accused
Part of that
activity.
activity.
Or, Your Honor, please let the other stuff go.
Got it.
Along with that, on the defendant's side, you could ask the court to increase the bond too. If we're talking about significant amounts of money and, withholding or the restraining of that funds will affect the defendant's business by preventing those funds to be used for advertising or inventory purchases. That can be effective too. And in our experience, courts are pretty amenable to those situations.
Got it.
And to those requests.
With just the couple minutes we have left, okay, you've got a business out there. They're in this situation, right? Their funds have been frozen. And I know one answer is it depends for sure, right? But how long? How long does the process of getting funds released typically take in your experience? Is there a sort of benchmark parameter?
If the matter isn't settling, in settlement, settlement is on balance the most common means of resolution for defendants in these Schedule A cases. Of all of the defendants who are involved, a good portion, we'll just qualitatively just say a good portion, they're never going to respond to the case, and they're just going to get defaulted. Either they never hear about it legitimately, and they have other things going on, and they just can't pay attention to it, or they think the cost of dealing with it outweighs, it's more than what the store is worth, either what's frozen or what the volume was, and they can go acquire another storefront another day, so they just let it go. A subset of defendants will show up and actually, dispute, fight the merit that will actually defend themselves substantively, the merits of the case. I think if settlement is impossible and the plaintiff is refusing to adjust, through a agreed order, for example, refusing to adjust the scope of an asset restraint, you filed a motion on Monday, a motion to modify an asset restraint on Monday. That's supported by a declaration from the seller with records of the sales records of the accused item or items at issue, showing that, and a snapshot of the store balance, showing the court, this is what's frozen, this is what we sold. Let's just assume costs are zero and profit is zero, so it's all revenue. At most, if we don't want to dither on exactly what our cost profile is and what the specific profits are, because remember, it's profits. The accounting of the defendant's profits, that equitable remedy is what's going to be justifying the asset restraint in the first place. Let's just assume profits are zero. It's all revenue. You're going to be at the mercy of how quickly the court's going to move around. So you file a motion on Monday. If the local rules in some courts will have automated briefing schedules. So say you're fortunate and the plaintiff has 14 days to respond. You have 7 days to reply, and then the court takes that under advisement. Maybe that takes a month or 2 months.
All right. Well,
it can take longer.
Sure.
Be floating there indefinitely sometimes.
Right. It's not an overnight thing, is what I'm hearing for sure.
No, definitely not. Definitely not. Well, so that's why it's, prior to expending resources on that effort, it's always worth the time to explore resolving the matter more amicably with plaintiff's counsel. These arguments are are very, very often had, and most any plaintiff's counsel is going to be cognizant of the arguments for and against what the parties are trying to do. I would say most judges in most of the courts in which the cases are filed have seen these arguments over and over again.
Right.
So you could file a motion if there happens to be a status hearing 2 days later, even though you're in the middle of a briefing schedule, the court might ask the plaintiff, so I saw this motion, what are we doing?
Yeah.
And then the plaintiff is going to, and then maybe the matter gets resolved that way too. Maybe the court, indirectly, lets the plaintiff know indirectly, hey, we've been around this bush before. Why don't you guys talk? And then come back with an agreed order, and that would be great. Because
I get it.
The court wants to be efficient with its time.
Yeah. Well, that's great. We got to go, Adam. Thanks for being here. Thanks for sharing your expertise and lots to cover. And I look forward to connecting on the next episode.
Yeah, thanks for your time, Sean.
You bet. That's it for this episode of the E-commerce IP Report with Adam Urbanczyk. To learn more about Adam's practice, visit the website AULLC.com. Thanks for listening, and don't forget to like, leave a review, subscribe to the show so you don't miss the next episode. Maybe share a link with someone in your world who's in the e-commerce business. Always helpful. I'm Sean O'Connor. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.